PLF separation of powers practice. Our other colleague, Damien Schiff, is viewing the Liberty Bell in Philadelphia as part of a PLF retreat, so will not be joining us today. Pretty quiet week at the court, but doesn't mean we don't have a few things to talk about. We're going to talk about here the to-do and the sort of opinions that have come out on the Calais ruling since that decision came down last week. And also, I think the other big story from the court this week is the mifepristone, the abortion drug ruling that the Justice Alito has decided to stay the Fifth Circuit's holding there. Those are the two main topics that I want to touch on in just a bit. But before we get there, Oliver, right before we got on, you were talking to me about your pride in Neil Katyal's decision to do a TED Talk. What are we talking about here? What is Mr. Katyal doing?
Well, Neil Katyal is a well-respected Supreme Court advocate. Argued over 50 cases before the Supreme Court. Our colleague Christina Martin bested him in I forget, Tyler versus County. I think it is a equity theft case, Supreme Court taking case that we won a few years ago. More recently, Mr. Katyal argued the tariff case, in which the Supreme Court ultimately ruled that Trump did not have emergency power under the IEEPA statute to impose tariffs and really to rewrite the tariff law.
And before we proceed to shit on Mr. Katyal, did a fine job in arguing that case, I thought.
Yes, no, he did fine. We would have made the same arguments. We also had a lawsuit against tariffs, of course. We were happy that the case got there. We're, of course, professional pride made us a little disappointed that it wasn't our case that got there, but nonetheless, we supported his arguments and the court's ultimate decision. Mr. Katyal did not file the case originally. He got involved later. The case that ultimately made it to the Supreme Court was brought by our friends at the Liberty Justice Center and Professor Soman from George Mason. But there was a dispute before the case started. Not a dispute, I guess, but there was a question whether Mr. Katyal would argue the case or whether Michael McConnell would argue the case. And McConnell is now a professor at Stanford. Before that, he was a judge on the 10th Circuit Court of Appeals, and there was a colleague with then Judge, now Justice Neil Gorsuch. And of course, McConnell is friends, good friends with Chief Justice Roberts. And so it seemed
most famously, McConnell mooted me in my argument for Cedar Point.
Yes, most important. That was his most important role in his life. But he's also obviously a conservative, whereas Mr. Katyal is a progressive on the progressive side of things. And in fact, that came up in the argument. Justice Alito asked Katyal during the tariff argument, did you ever think you'd be arguing in favor of the non-delegation doctrine? But McConnell not only was a conservative, but he, again, being friends with Roberts and working with Gorsuch, many thought, including myself, that it would have made sense for McConnell to argue because he can speak more credibly, I think, to the conservatives on these types of arguments. Nonetheless, Mr. Katyal argued for who knows what reason. Maybe the clients wanted it, maybe Liberty Justice Senate.
Maybe you want a coin flip.
And maybe want a coin flip. And the coin flip did come up because he won the coin flip against Pratik Shah, another well-known Supreme Court advocate, on who would do the argument for the private parties. The Supreme Court ordered only one advocate for the private parties could argue. Anyway, so the Supreme Court ruled against the tariffs, ruled in favor of Mr. Katyal.
I feel like you're burying the lead here. Why is Mr. Katyal back in the news?
I'm trying to explain the context. So so the other day, Mr. Katyal issued or did a tweet, or I'm sorry, did a TED Talk, and to promote it, he sent out this tweet, and the substance of the tweet and the TED Talk was basically all about himself. And he tried to say that he tried to give props to some kind of a bunch of coaches somebody who does work with athletes, pro athletes, big name pro athletes. Some, I think, an improv coach who supposedly taught him to say yes and to the Supreme Court, as if other Supreme Court advocates and lawyers in general don't know that. And then I forget somebody else, and then also Harvey, which is an AI tool, which I guess he's worked on. But in any event, it's clearly a sales pitch for Harvey. But it just the talk and I didn't actually watch the talk. I read some of the transcript, but the tone of the tweet was just over the top in his preparation, in what he thinks that he alone convinced the 6 members of the court to rule in his favor. He said that no one thought that they could prevail. He had a colleague that told him no, law professors. So, there were a lot of cases because a lot of people thought it was possible to win this case, and that there were a lot of good arguments against the president here. So it just, and it's one of those things where, he doesn't need to brag. He's got the credibility. He's got the receipts, as they say now. So just a very strange circumstance of a well-known, credentialed and accomplished Supreme Court advocate, just doing way too much to toot his own horn.
Yeah, just completely tone deaf and just missing. Sarah Isker, who's all over the place now, most famous Supreme Court commentator, after us, of course, I think is Sarah Isker. So she's quoting one of her friends to say, quote, "I hope Neil knows he just announced his retirement in the form of a TED Talk because he could never appear in front of the court again." I mean, it's beyond the pale. And for someone with a reputation that he can lean on to do something so ridiculous, I don't get it.
Do you remember at the hearing, at the oral argument for the tariff case, I forget his name, a Saturday Night Live guy, a former Saturday Night Live performer was at the hearing, and apparently
It was
Maroney,
John
Mulaney, yeah, because he and Kat Yeller are apparently developing a sitcom based on a lawyer. I don't know.
I do think that I mean, if I'm trying to put myself in Mr. Katyal's shoes, I think he views himself as like this famous pop star.
Yeah.
And like he's going to turn this into a sitcom, and he's going to be on the TED Talk circuit, and he's just like this, I don't know.
Well, he's like his former boss, President Obama, who likes to be a celebrity.
There you go. Anyway, is this top 3 most embarrassing moments of Neil Katyal's career? This, his TED Talk, his picture where he's at what's that festival?
Burning Man,
where he's wearing like a beanie or something.
Yeah,
He just looks like a complete jackass. Or his decision to argue in favor of cities that steal equity from poor old ladies that have nothing else.
I think before the argument or right after the argument, he again promoting himself said something like that he's humbled by that this will be his 50th argument or something like that. And I was joking, Christina should have said, "Oh, really? This is my first." and she won. But of course,
I know, I believe.
Yeah, but as you say, his case was terrible. So it was an interesting decision, like you said, to take on the case.
Yeah. Well, I think he just has no shame, right? He feels like the numbers matter more than like being on the side of justice or being care what people think of him. Not any grants. The order list came out this week. Back to actual Supreme Court news. No grants on this week's order list. No arguments. Arguments are done. So we are in complete opinion watch. The court has announced opinions for next week. Or the likelihood that I think on Thursday there will be an opinion or 2 or 3.
Okay.
So
how many more? I should know this, but how many how many opinions are still to be released before the end of the term?
That's a good question. I think we can figure that out real quick by going to the Supreme Court's website, which I will say. But there were a few interesting opinions. We are on opinion number. Oh, I thought it would. Oh yeah, we've had 30 so far this year. So First Choice Women's Resource Center, which was last week's. That was the 30th opinion of the year. Which, assuming they've taken, 60 or so this year,
Yes.
we're probably halfway through.
Yeah, still a good number to come.
Yeah. So let's talk about, where do you want to start? Do you want to start with Danco Labs or Calais?
Either one. I don't know. You're going to talk more about Calais, so although I can, yeah, whatever you want.
All right. Well, Calais, let's start with Calais. Calais was the decision, came down last week. Damien and I talked about it quite extensively on the show, where the Supreme Court held, not that Section 2 of the Voting Rights Act is unconstitutional, but essentially ruled that what Louisiana did in purporting to comply with Section 2 when it used race to draw a minority-majority district violated the Equal Protection Clause. And in so doing, it did a couple of important things. One, it recognized a third compelling interest, which is compliance with the Voting Rights Act. So if the Voting Rights Act compels a state to use race in order to meet the needs of the 15th Amendment, the Supreme Court said you can do that. But it also said, when we say compliance with the Voting Rights Act, this is what we mean, and laid out a new test, or at least an updating, I think they called it, of gingles or jingles. Damien and I had a fight about whether it's gingles or jingles. And that new test brings the Voting Rights Act in line with sort of traditional equal protection principles. We don't need to go rehash it all, but essentially that in order to that you need to demonstrate that you're actually remedying past discrimination. You need to demonstrate that you're not just drawing districts along partisan lines, that they are being drawn along racial lines. So you have to actually show these discriminatory factors. That's what the Supreme Court does, and so doing strikes down the map. Louisiana, now we're moving into what happened this week. Louisiana asked the court to issue its judgment forthwith. Typically, the losing side in a Supreme Court case has 30 days to seek rehearing. Louisiana said, or 45 days maybe. Set that aside.
It's weird. It's a weird. Yeah, I don't know.
Yeah. But let's set that aside because we need to have an election here, and we don't want the citizens of Louisiana to proceed in an unconstitutional map. The Supreme Court obliges and issues that judgment.
Yeah.
So the opinion goes into effect immediately. My understanding, and I don't know a whole lot about this, but Louisiana is either undertaking new maps or it already has new maps in place, whatever. The point for our purposes is that decision by the Supreme Court to make it go into effect immediately drew a pretty strong rebuke from Justice Jackson, where she alone, it's her own opinion, she takes exception with the court's decision to let it go into effect immediately, not allowing the Robinson plaintiffs, the Section 2 plaintiffs, and to allow for the time to seek rehearing. I think if you're being generous, her take is that the normal course of things is to let the 45 days play out. The Supreme Court is going beyond what is its normal course here, and there's no reason to do so. And it's only doing so for partisan reasons. She calls the court groundless and irresponsible. And I think that was one step beyond the pale for Justice Alito.
And she also said that principles gave way to power. It was raw judicial power, to borrow from a different case. Alito responded and said the dissent's comments cannot go unanswered. And I think he was joined by Thomas and Gorsuch, I think.
Yep.
And said that a couple of interesting things, but he said, what principles are we talking about? That the court can never shorten the time for issuing a judgment, even though the Supreme Court rules expressly allow that.
Yeah.
But he pointed out the one thing that gets to the issue, perhaps, is he said that this case was argued 7 months ago, and we conferenced it 7 months ago, suggesting that everyone knew what the decision was back then,
Yeah.
and that maybe the dissents took their time so that the court could not issue its opinion until just recently, and that so if anyone was playing politics, perhaps it was Justice Jackson for not getting a dissent in a timely manner. And so, in fact, the one who was playing politics maybe was Justice Jackson and not the majority.
Which, yeah.
Who knows?
So if you remember, it was Justice Kagan who wrote the dissent in this case. So Justice Jackson didn't write one, which makes one wonder, did she have one in the chamber that she was just delaying? And that's what Alito is hinting at. Or was it that Justice Kagan was the one delaying? Or maybe are we reading too much into it? But either way, his point, I think, still holds, is that this isn't a big surprise that we were going to come down with a judgment. We heard the case 7 months ago, and
we knew what the judgment would be.
And we knew what the judgment would be.
Yeah.
Right. So he makes 2 points. He said, the one that you noted, that there are circumstances where you're going to set aside the 45-day rule. And the fact that we have an election coming up is as good of a reason as any. And the fact that we've had this case before us for 7 months is as good a reason as any. The other point that I thought was clever, I mean, I think Alito's a great writer, is he said, is the other principle that we're violating that we can never issue an opinion that has like political overtones that may be perceived by some to be partisan, because we're going to be doing that all the time. And that can't be the reason why we don't do what we think is just and right. And pretty strong rebuke, I think, from both sides. I mean, this isn't the first time that Justice Jackson has issued opinions that I think are a bit unhinged for the decorum of the Supreme Court, but it is one of the first times I've seen Alito really strike back and to be joined by 2 other justices. Now, I do remember, was it last year, there was a back and forth with Barrett and Justice Jackson. I forget what that case was.
Yeah, no, you're right. And somebody else pointed out, neither Kagan nor Sotomayor joined this most recent dissent.
Yeah.
And they joined, and obviously, as you pointed out, they did dissent to the merits, the substantive issues.
And Kagan felt so strongly about it, Justice Kagan, that she read a lot of her opinion from the bench, so much so that her voice became hoarse for the oral arguments that followed. So she obviously felt strongly about the decision, but nevertheless refused to join Justice Jackson's separate opinion here.
And nor did she or Sotomayor suggest that the decision to issue the judgment quickly or immediately was wrong.
Yeah.
She could have dissented and just said, I disagree, we should give the other side the full time to file a motion for reconsideration. But she knows or apparently believes that there's no grounds for a motion for reconsideration, that she disagrees with the judgment of the court, but there's no reason to slow it down at this point.
One other note about this, so we talked about sort of the concurral in the judgment and the dissental. The actual opinion essentially says, well, there's been no motion for rehearing, we don't see one coming, so we're going to issue the judgment. Lo and behold, after they do that, the next day, the Robinson plaintiffs do issue a modus to recall the judgment and would like rehearing. I think that was a little bit, I don't know, day late and a dollar short, and the Supreme Court just denied that with no opinion on that.
Now, I think they did say that the plaintiffs did say that they were considering it or something. But if time is of the essence,
Yeah.
and the other side has moved to file the judgment immediately, I think you need to do a little more to preserve to preserve the claim.
Yes, agreed. Let's move next to. Oh, I wanted to say one more thing on that. As I was going back and reading so these are not official opinions from the court. They're called, if you look on the court's website, there's opinions relating to orders, and this is an opinion related to an order. And as I was going through there, and I clicked on that link, I noticed, there's been a number of them this year, usually by dissenters of some kind. And I was reminded of, there was an Alito and Sotomayor back and forth on another Voting Rights Act case. This was the one, if you recall, from New York State, where there was New York had created new voting districts that they explicitly did so on the basis of race. And the plaintiffs who had sought to enjoin that were being kicked around in New York State courts, and they sought a stay in the Supreme Court, and the stay was granted. Justice Sotomayor wrote a dissent from that saying, this usually we let things percolate, essentially. And Justice Alito had written one to say, like, look, this is the most blatantly unconstitutional rule in the entire world. If we can't, wait a little bit, if we have to wait a little bit and allow this to go into effect, we're going to be running into the same problem we're having in Louisiana, which was foreshadowing. So I think there was some foreshadowing in those dissentals and concurrals from March that
they knew what was coming.
Played out this time around. Anyway, let's move on to, can you try to pronounce the drug?
Mifepristone? I'm sure that's not right.
And in there. This is the mifepristone. This is the abortion drug. I think you take it and will induce a miscarriage. And this was the subject of a lawsuit that made its way to the Supreme Court in 2024 called Alliance for a Hippocratic Oath versus FDA, I believe, where a number of doctors brought suit challenging the FDA's allowance for this drug to be prescribed not in person. So the doctors argued this was causing a number of harms to them. The Supreme Court rejected that and said they didn't have standing to bring suit. This is the continuation of that same cause, albeit with new plaintiffs this time. And the state of Louisiana, along with an individual, I believe, has brought suit challenging that same FDA decision to allow for mifepristone to be shipped across state lines to individuals within states where abortion is illegal. And so they argue there's various harms with this. In particular, I think Louisiana, I read, says that, there are certain costs associated with Medicare that we have to pick up when this goes badly, which I think everybody sort of agrees to. I mean, whether that's enough for standing, I don't really have well, we can talk about that in a minute. The Fifth Circuit, again, just like it did in the first time, held that so it's an APA challenge. They're saying that the FDA did not have the evidence before it to issue its new rule that would permit shipping of this drug to patients that haven't had an in-person visit. And the Fifth Circuit agreed that essentially the APA was violated. They needed more evidence. What's helped them along the way is that there's been a new administration, and the new administration has decided to undertake new evidence gathering and has sort of disavowed the previous decision to allow this. So there's at least a pretty strong case that they're going to win on the APA claim when there is unanimity between the government and the parties bringing challenge. Now, the government doesn't believe the injunction should be issued, so we're on a preliminary injunction, because it says, let's leave it in place while we gather the evidence and issue a new rule. Louisiana says that's not good enough. We want it enjoined immediately. Our citizens are being harmed. Fifth Circuit enjoins it immediately. They seek a stay. Both the drug companies seek a stay of that ruling in the Supreme Court. And this is what has sparked off this debate anew when they asked the Supreme Court to stay the Fifth Circuit's ruling and preliminarily enjoining the law.
Yes.
that allows for in-person or allows for delivery of this drug through the mail.
Yes.
And that has created a storm of controversy.
And Justice Alito, who was accused recently of playing politics, granted the stay, which means that, as it stands, the drug is available in Louisiana. And one would have thought if Justice Alito was playing politics, and one can, especially since he wrote the Dobbs opinion, which overturned Roe v. Wade, that he would deny the stay to keep the drug off the shelves or out of the mails, however you want to say it. So, as you said, though, Danco, which is one of the manufacturers of mifepristone, I think.
Oh, that was good. Mifepristone.
Said that that the decision from 2 years ago controls, that there still is no standing. The Fifth Circuit apparently held that Louisiana is standing because, as you said, they have to spend some money on Medicare. Who knows if that's enough? But interestingly, the Fifth Circuit said that they're standing because there's a mismatch between the state's policies prohibiting abortion and the federal government's determination of how to balance the statutory factors that Congress directed the agency to consider in modifying its conditions of use, and other states' laws that diverge from Louisiana. As the drug company argued, though, the states have no sovereign interest in how other sovereigns police their statutes, and they quoted Dobbs and said that by returning abortion policy to states, you're going to have this kind of divergence. The Fifth Circuit also said, I'm sorry, and then so the Fifth Circuit basically said that, of course, this injunction should be put in place. Again, it's another injunction case which drives me crazy, just because we have so much trouble getting injunctions, and it seems like everybody else can get one. Now, of course, this is the Fifth Circuit, so that's a little more understandable on these things. But I joked with someone today, in fact, that the standard for irreparable harm went way down between 2021 and 2025. No, when was Trump? 2017 and 2021, and then since 2025 again, when Trump was in office. So anyway, one of your hobby horses is the ridiculously high bar for standing in general, and so this case kind of brings both of those issues to the fore.
Yeah, you're right. I'm always skeptical on courts picking cases on standing. Just get to the merits. It feels like the primary justification for a robust standing doctrine is, the courts would be just filled up with all of these frivolous cases. Well, now they're just filled up with litigation over standing. It's just a ridiculous. Yeah.
And why should states be the ones litigating these kinds of issues?
Yeah.
I'm not sure doctors, if we're gonna, I don't know if doctors have but they seem to have more of an interest than a state would.
Yeah.
And again, standing based on federal Medicare subsidies seems like a strange basis for standing.
And what I also, on the other side of it, what it seems odd to me that Danco is the entity arguing against standing, like a private party is arguing against
Yeah, it's good. That's a good point. And I think I read that the FDA has not filed a brief in the most recent, probably maybe because they're changing positions. So I wonder if the court will assign an amicus. Well, they did assign an amicus, didn't they? I think it's a former Alito clerk. Was that this case? They just assigned a former Alito clerk to argue a case.
I did hear that. I didn't put two and two together that was for this case, but I did hear.
It might not have been. Maybe I just made that up.
No, it could very well be. It makes sense that they would. I want to say a little bit about the merits of this. I mean, what the actual merits are, I don't really have an opinion on. I don't know. I mean, I'm sure Damien, maybe even you have a better understanding of the APA claim here than I do. But I will say that, we have our telehealth cases, right, where we are arguing that prohibiting patients from speaking with cancer specialists out of state via telehealth when it's just speech is a violation of the First Amendment. I think we stand on pretty strong ground there, at least post-Childs. There's some of that in the background here, and a lot of the pushback that we've seen from legislatures where we've gone to seek telehealth reform is that, oh, then you're going to allow us to, you're going to undercut our interest in life, and that you're going to allow these abortion drugs to be sent in here. Now, I think there's a line to be drawn between prescribing drugs and pure speech that can happen, and I see no reason why a Louisiana patient shouldn't be able to speak with an abortion doctor in Texas over telehealth. Now, I also have come to learn that most states sort of allow out-of-state doctors to prescribe medicine. So I wonder what exception would allow them to draw here. These are the thoughts like sort of bumming around my noodle. And relatedly, like, what's the interstate commerce implications of this if there's sort of like state barriers to certain products that are otherwise legal nationwide?
Yeah, it's the Comstock Act? Is that the one that banned lottery tickets or something, or taking women across straight lines for immoral purposes? Yes, you'd think that the Commerce Clause could trump this kind of stuff, but then again, there is the long tradition of states regulating health and safety. Yeah. So yeah, it's an interesting question, but yeah, as a general matter, this seems strange that the states can prevent this kind of stuff. If you want to talk to a doctor outside of your state, it seems like you should be allowed to without punishing the doctor.
Okay. Now, the briefing has been completed, I think, earlier this week, right? And so we're just the stay that Justice Alito issued was only for 1 week, and I did see that I noticed that the Alliance for ADF has joined Louisiana as the petitioners in this case. They have asked for the extraordinary remedy is if you feel compelled to keep the stay in place, grant certain oral argument before the summer recess.
Wow.
Yeah, I saw that as one of their arguments in the brief. So, I mean, that's quite the ask. But maybe we'll be back here next week with something to say about what has happened in this case.
Yeah, well, I think the court should take more cases. So.
Yeah, of course.
So why not?
How many petitions do you have before the court right now?
None.
Oh,
I don't think. I'm waiting for the Pennsylvania Supreme Court to make a decision.
All right. Well, I just filed 2 weeks ago the Katibi petition, so hopefully the court will take that case.
When will that be conferenced? Do you know?
It's going to depend on whether the state of California responds, or whether they waive their response, and whether they order a response.
So it could be the long conference?
Could be the long conference, yeah.
Okay.
That doesn't really bother me.
Yeah.
Anything else from the court this week that you wanted to talk about?
Well, I wonder, are we going to get any retirements? I don't think there's been any word lately. Justice Thomas just became the second longest serving justice in the history, and I think 2028. So he still needs 2 more years or so to get to be the longest. But it is interesting that there's a lot of talk about the Senate and whether the Republicans will keep control. So I suppose if Alito or Thomas were considering retirement, they would probably wait till after November to announce and not do it this year. But who knows? They're both still sharp. But you never know. It's I don't know what to do.
Yeah, right. And this talk, I find it a little bit unbecoming, but it happens every year, whether it was the last year of Biden, or everybody's looking for Supreme Court justices to retire.
What do you think about like an 18-year term? Would that bother you?
Well, I think it would offend the Constitution.
Well, no, the way to do it, apparently, this is from our buddy Tommy Berry, who can be found most of the time as the first person in line for Supreme Court oral arguments, right
With a
outside,
can of tuna.
with a can of tuna. That the way you could do it is you'd still have a lifetime appointment. They would just go to circuit courts or be visiting elsewhere. So you'd still they wouldn't be fired, and they wouldn't be, but it would just the Supreme Court term for
That's a
each
fair
person,
point.
18 years.
I think, there's probably 20 Supreme Court reforms that I would support in one fashion or another that will never get adopted.
No, that's although the way that I think there's a, I mean, I don't know if there's a way to guarantee it, but you could stagger things out, and
Never going to happen.
probably not. But I did it as a matter of principle. It doesn't bother me. And I think I don't know if Tommy's done the math, but he told me someone has done the math that if 18 years would actually, at least over the past 200 plus years, that would work out so no party would dominate, supposedly. But who knows?
Well, that brings me to Supreme Court trivia for the week. Now, last week, I was quizzing Damien on these very things, the longest serving Supreme Court justices. But I'm going to take it a little bit further. This isn't for you because there's no way in hell you're going to know it. But
It's a little insulting.
the longest serving Article 3 judge in our nation's history served how many years, do you think?
45.
56.
Wow.
From May 1801 to 1857.
And that's a long, was he appointed when he was 12? That's a long time ago, too.
That's a long time. And the second longest was 54 years by, you'll recognize this last name from old Supreme Court opinions, Cranch.
Oh, okay. Yeah, oh, yeah. That is, I was just reading about him. He is related to John Adams, I think, or
is that right?
by marriage, maybe.
He was appointed by John Adams.
Okay. Yeah, maybe his wife's something. Some connection.
All right, so here are my real questions for you. Who is the longest currently active Article 3 judge?
Well, is it the woman from the Federal Circuit?
It is.
I forget her name, but who's currently on administrative leave or something.
Yeah, Pauline Newman and our friends at NCRA, NCLA, have a petition, I think, outstanding, arguing it's not really on the merits, though. I can't remember exactly what it was. But,
Yeah, I can't either.
all right, moving on. So she's been on the bench for 42 years.
Wow. And she's in her 90s though, right?
Yeah, she's in her 90s.
So that's impressive.
The second longest is a district court judge out of North Carolina, Terrence Boyle.
Okay.
He was up for apparently some Fourth Circuit nominations earlier. The next three are all Reagan Circuit judges that you know. So go.
Edith Jones.
She's the third longest of those ones.
Wow. Is
Right,
Sykes?
she's still she's not even senior, right? She's just,
No, Sykes. She's too young.
She's way too young. I think she retired anyway, or she's not active anymore. I'll give you a clue. Fourth Circuit and Seventh Circuit.
Fourth Circuit and Seventh Circuit. Oh, Easterbrook? No.
Easterbrook, yeah.
He's still there? Wow.
Yeah.
Fourth Circuit. Oh, my buddy Jay Harvey.
Yeah, exactly.
The guy who
Very
yelled
good.
at me for 20 minutes.
Wait, what was that?
That Jake's fireworks argument, we argued that the CPSC, Consumer Product Safety Commission, had issued a final order, and therefore we should be able to seek judicial review. And he wasn't even looking at me. He just looked straight ahead and was railing about how fireworks might not be the most dangerous thing, but other things will be dangerous. We can't have the blah blah blah. And then when the government's lawyer got up, he was yelling even louder. And then at the end, in the Fourth Circuit, when they're done, they come down and shake hands with the
Yeah.
lawyer. So he
Yeah.
came down and he was doing fist bumps for some reason. So, so he gave me a little fist bump. But yeah, I don't know. I haven't looked at the transcript, but I kept trying. Like, Judd, you're on. Yes, but and he just kept going. So,
Well, when you've been serving on the federal bench for well, let's see how long, 41 years,
Wow.
you can rail against Ohioans
yeah,
like
and
that.
he's a big. He used to be, at least. I think he still is a big feeder for Supreme Court clerks.
Mm.
I think our buddy Austin Rayner clerked for him.
Oh, is that right?
I think so.
And a few others of note here. Clarence Thomas is 84th all time in just active judges, because he's also, you got to add on the little under
DC.
on the DC circuit, 36 years, and because of that, Justice Alito is almost more than Clarence Thomas. They were both appointed to the circuit courts by HW in 1990,
Wow.
but Clarence was appointed about 2 months before Justice Alito. So,
Very interesting.
and then speaking of yelly judges, Judge Loken, who is still on the Eighth Circuit and has yelled at many a PLF and other lawyer. I'm pretty sure he's also still an active judge on the Eighth Circuit. He's been there for 35 years, and I didn't know that in a case that we found in the amicus brief, Judge Loken put out an opinion yesterday that basically
yeah,
adopted
I saw that.
PLF's arguments in the Fair Housing Act.
Yeah, good.
Fair Housing Act? I don't remember.
I don't know.
It was a disparate impact case, but
Yeah.
anyway. Well, Oliver, that's the Supreme Court trivia for this week. I think next week's edition of the PLF Supreme Court
I,
show.
won, I won this round. I won this week's trivia
You did
contest.
pretty good.
Yeah.
I'll give it to you. Yeah, well, we should have some opinions to talk about next week. Maybe some grants. We'll have an order list, but maybe something on give me the drug's name again.
Mephistoprone.
Mephisto. I still
got
can't
it
say
now.
even when you say it right in front of me.
Yeah.
Maybe we'll have more on that. But anyway, thank you for joining us. Thanks to all our listeners. We'll be back same time next Friday to hear more about the Supreme Court. Thank you, Oliver.
All right. Thanks.
Have a good
Yeah.
week.